Hello, everyone, and thanks for joining our webinar today. If you're joining us today, we are talking about how real estate works when people get divorced, especially here in Nevada. And this is our webinar on navigating divorce for the real estate professional. My name is Molly Rosenblum, and I am the owner and founder of the Rosenblum Allen Law Firm. I've been a licensed attorney here in Nevada for 20 years. I grew up in Las Vegas. I attended college in Reno. I've raised two children here in Las Vegas and am married. Uh, I've owned three homes here in Las Vegas and started my practice about 17 years ago. Currently, my office is one of the largest divorce firms in Nevada in terms of case management. We've handled thousands of divorce cases, and we carry about 120 to 150 divorce cases at any given time. We've litigated hundreds of cases to judgment, and we're pretty well known in the divorce arena, and we do a lot of divorce cases involving people's property. So here we are today talking about that for you. Just giving you an understanding about what we're going to talk about today. Our webinar, we're going to look at how Nevada rules about property and divorce affect houses. We're going to talk about the Nevada divorce laws and how those apply to real estate. We will talk about the intersection of divorce and real estate and how just how these two ideas of divorce and real estate law kind of connect and what the issues are that we see with both. We'll talk about the role of the real estate professional in a divorce case and some of the challenges that you can have for selling property when people are going through a divorce. We will talk about some different strategies for residential property and commercial property. And we'll talk about commercial property in the context of a divorce. We'll talk about legal and financial considerations, including liens and some checklists for compliance to make sure that you're compliant. And then we'll close it out with just some additional information about us and our firm. So diving right in, as we move into our next slide, we're going to talk about understanding divorce law in Nevada. And in this slide, you see that we're going to present an overview of Nevada's divorce laws. We're going to break down some of the key terms and concepts that are essential for real estate professionals. We'll walk you through the divorce process step by step, and we'll give you a clear picture of how divorce can impact real estate transactions. If you are a real estate professional, just having some of this basic legal background will be important for you. So just kind of giving you an overview of Nevada divorce laws. Nevada does have a residency requirement in order to get divorced in Nevada. One of the parties, so one of the people you're dealing with, must live in Nevada at least 6 weeks before they file their divorce case. And that is the residency requirement. So you only have to be in Nevada 6 weeks, and if you've been here 6 weeks and can establish a residency, then you can file for divorce here. On top of that, you also have to have grounds for divorce. So that means one of these three factors, which is incompatibility, living separate and apart for a year, or insanity. The one that we see the most is incompatibility. You don't have to prove that you're incompatible, or the clients don't have to prove they're incompatible. They can just say, hey, we are incompatible, we don't get along, and we are not going to reconcile, and we want a divorce, and our court will give them a divorce. One of the questions you may face as a real estate agent or somebody working in real estate and being involved with real estate and divorce is, how long is this going to take? It is a question that we faced often, and there's really no way to predict, especially here in Las Vegas, how long a divorce will take. An uncontested divorce can take anywhere from a couple of days to a couple of months, depending on how much negotiation goes on back and forth. But usually once the case is filed as an uncontested divorce, it goes pretty quickly, usually within a week or two. From the time the case is filed until they're done, the parties will be divorced. A contested divorce case can last years on the outside. It can also go very quickly. If it's contested, but nobody actually appears to contest it. But generally, a good rule of thumb on how long a case can take is about 6 to 8 months. So if you're representing sellers with regard to a marital residence and they have to wait until their divorce is final before they can sell or distribute their money, and they're asking you how long will it take, you can tell them usually, your experience or what you've been told from divorce attorneys is about 6 to 8 months. And then where do we find Nevada law is in NRS 125. Those are the Nevada revised statutes. And then 3 cases that affect uh, divorce and real estate in the state of Nevada that are pretty important is our Springer versus Springer case, a 1992 case. That clarifies about separate property and how that gets considered as community property, and how that can be divided. Another case is the Keller versus Keller case, which talks about dividing community debts. And then Potter versus Potter, which talks about how to value and divide community businesses in a divorce. So just a little bit of background for you. Hopefully you'll never need that. Hopefully you'll be working with divorce lawyers who can give legal advice to the people that you are representing in their real estate transaction. So some key terms and concepts that you may need to know if you are dealing with divorced property. One is community property. So a good way to think of community property is anything that the parties have during their marriage or acquire during their marriage is going to be considered community property. On the other side of that, we have separate property. So separate property is generally anything that they had before the marriage. So if it's something like a house that somebody owned before the marriage, likely that is going to be considered their separate property. And then our law in the state of Nevada talks about equitable distribution. So a lot of people think that when they go through the divorce process, everything is divided 50-50, and that is not exactly what our court requires. Rather, they look at an equitable distribution, meaning that it's fair. So not necessarily equal, but a fair distribution of assets and debts. And then another term that we use when we are dealing with divorcing parties who have real estate is a real estate valuation. And that can come from a variety of different sources. So that could be appraisals, that could be market comp analysis. Some people use different metrics for that and how they get there, but establishing a real estate valuation is usually necessary in order for us as the attorneys to divide people's real property. And then maybe the last term you might want to know about is alimony. So a lot of people are familiar with this concept, but in Nevada law, it just means a payment that one spouse makes to another for the support of the non-paying spouse. So those are some key terms and concepts that we deal with as lawyers with folks going through a divorce, and particularly as it relates to their real estate. So the divorce process in Nevada, and we are going to cover this rather quickly, is first filing a complaint for divorce. So it works just like any other case. You have to file your complaint. And once your complaint is filed, you are off to the races. Then the complaint in Nevada has to be personally served. So you need to serve it on the other spouse. And then there's a response period. And so once the spouse is served with their complaint, they have 20 days to respond. From there, usually what happens is the attorneys will get together with the litigants and we'll talk about negotiating some kind of agreement, especially when there's real property involved, like a home or some other real property, vacation homes, timeshares, things like that. We'll sit down, we'll have a conversation and see what we can do, what agreements we can reach to start getting those boxes checked and getting those assets distributed among the parties. If the parties cannot agree, then we have court involvement, and that can end up in a trial, and that could end up with a court telling the parties what they are going to be doing with their property. And finally, after that, we get a decree of divorce. So once all is said and done, whether the parties reach an agreement on their own or a court tells them what to do, you will get a decree of divorce, and that should be the final document in a case, and that should explain what is going to happen with everybody's property. In our jurisdiction, we also deal often with post-decree modifications, and that usually happens either when one party thinks that maybe a distribution isn't fair, or they reached an agreement they don't like, or when they need to clarify some terms of an agreement. So as we move on, the next part that we'll talk about is the interplay between divorce and real estate. And this part of our discussion will focus on key considerations for property division during a divorce. And we'll talk about some common challenges that can arise for real estate professionals as well as attorneys when you're dealing with divorce and people's real property. It's important to understand these elements and create a situation where parties can navigate the real estate transactions effectively in the context of a divorce. So some key considerations in property division during divorce. It's important to kind of remember some of these things with regard to residential property. So how we value a property and the possible sale of a residence, including the marital residence, is usually the first thing that we are looking at as divorce practitioners. So the first thing we're going to look at is, what is the value of this residence, and do we need to get it listed for sale? That's usually the first thing. The court wants to know, what are these parties going to do when they're not husband and wife anymore or spouses anymore? And where is the home going to go? Is one spouse going to buy the other spouse out? Are we going to get that house listed for sale? If we're going to list it, how much are we going to list it for? And what happens if we don't get our asking price? Then what do we do? So those are some of the considerations that we're looking at. Other considerations can also include not only selling a residence, but representing folks who are looking to purchase a residence once their divorce is final. And a lot of times what we see in our practice is people who need to get a mortgage, and they're waiting on an alimony award, and whether or not they're going to be able to qualify for a mortgage depending on how much their alimony is. So that's also something to consider if you're representing a buyer who's going through a divorce. What are they going to get out of that divorce settlement? Are they going to have enough to put a down payment? And if they're getting an alimony award, are they going to qualify for a mortgage? The other thing to consider is also looking at refinancing. So if you're a lender and you are in the business of refinancing, will that person qualify to refinance the home on their own, or do they need assets? Do they need to pay down some of the mortgage? And how, if they are refinancing and they're taking some equity out, is that getting paid to the other spouse? So those are some of the considerations that you will probably face as a real estate professional when you are dealing with folks who are getting divorced. So, and that is as it relates to residential property. As it relates to commercial property, the biggest challenge that we face as divorce attorneys is getting business valuations and how that commercial property plays in. A lot of times, the commercial property in and of itself is a separate asset apart from the business. And so how we value that and what happens to that property, that commercial property in the event of a divorce, is a big consideration when we're going through that process. The other issues that we deal with and that you need to consider is, what happens if the divorcing spouses both own the business together and the business owns the property? How is that going to be dealt with? And you, as the real estate professional, who are you representing in that situation? Are you representing both spouses? Are you representing the business? And how do you deal with that? And then some other considerations are also the complexities of dividing and selling commercial property. So how do we create a market? Sometimes there isn't one for certain types of property. Sometimes commercial properties that have um, certain businesses on them can't be sold by law. And so those are considerations that you'll need to think about if you're representing folks going through a divorce. And so when we talk about real estate in the midst of a divorce, we're not dealing with properties and numbers. We're navigating through people who are going through really emotional, complex times and some pretty significant life changes. And so, how we balance the financial implications of a property division and also be sensitive to what our clients are going through is really, really important. Um, it's important to consider that you're a person first, and your clients are people too, and they are usually going through what is one of the most challenging times in their lives. And so the decisions that they're making with regard to their finances can really have a very long lasting effect. And it's important to kind of think about that as you move through helping these folks through a sale of their home. And so, one of the biggest issues that you may deal with is somebody who has an emotional attachment to their property. Um, People who feel like they just don't want to give up that marital residence, they don't want to sell it. This is where they raise their kids, or this was some of the happiest times of their lives, or also some of the saddest, and they just have a hard time letting go. And as an agent, it can be difficult to help somebody navigate through that. The Another challenge that you may face is a valuation dispute, and I often don't envy any agent who's involved in a valuation dispute between spouses. It is difficult for the attorneys to deal with valuation disputes, and I can only envision how difficult it would be for a real estate professional having to hear both sides of that. And so it's important to kind of keep your client focused, particularly if a judge has ordered that this is what the house is going to be listed for. You may often hear from somebody involved in the transaction that they don't agree or they're not happy about the listing price. And sometimes, just kind of redirecting them and telling them, listen, this is what's been negotiated, or this is what the judge has ordered, can be helpful. Another challenge you may face is debt and mortgage issues. So, we see this often as divorce attorneys, where we have a client who they don't want to let that marital residence go. They don't want to sell it. They want to keep it. It's their home, and they are going to, come hell or high water, they are going to refinance that property. And sometimes they just can't. They don't qualify. They don't have enough financing to be able to make that happen. And it can be very traumatic for that person to understand that they're just not going to be able to hang on to that house. And so that is a huge challenge, I'm sure, for real estate professionals, and just something to be mindful of as you navigate through the divorce process with your clients. Another issue, obviously, in our environment here is just market conditions and how that can affect a sale. A lot of times you'll see clients who, gosh, they really want to get that house sold. They want to move on to the next step of their life. They need that money to move on. And the market conditions, the house maybe just isn't moving fast enough. And so that can be a real challenge. And another issue you may face is just legal and tax implications of having this house sold, and what that could do to somebody's tax liability. And even though I'm not a tax professional, and I'm sure many of you are not tax professionals, that is something to consider. And, usually just referring them to a tax professional to talk to them about what the consequences are going to be if they're selling this real estate and what that looks like for them. And then finally, is another challenge you may face is an agreement on the property division. And this is where working with the attorneys is absolutely critical. If you're sellers are represented by counsel, making sure that you're having a dialogue with the attorneys and having a clear understanding of, okay, once this property's sold, how are we going to divide the proceeds? What is going to happen to that money? Where is it going to go? And it's super, super important that everybody is on the same page and working towards the same goal. So now I want to talk a little bit about the role of a real estate professional in divorce situations. And we're going to cover 3 different areas. The first is going to be ethical considerations and some professionalism. We'll offer you some best practices for working with clients who are getting a divorce, and then navigating communication between the parties and the lawyers. So let's kind of dive into this part. So as far as the ethical considerations, we felt that it was best to create a do and don't checklist. On the do side, obviously maintaining confidentiality is important, even though as a professional, you may not have an obligation of confidentiality. It's important that your sellers or your buyers understand they are going through a divorce and they may not want you to share certain things with the other side of the divorce. And so just kind of maintaining that confidentiality, taking in what they tell you and not divulging it to the other side is super critical for trust as a professional. The other thing that is absolutely important and we strongly recommend is that you provide impartial advice. We see as divorce attorneys where our clients feel like the realtor has taken the side of the other party and they feel like that realtor's biased, they're not giving them good advice, and they want that realtor removed, and that can cost you a sale. And so it's super important that if you're giving any kind of advice, it be consistent on both sides, that it be impartial, and that you not favor one side or over the other. We strongly recommend that you stay informed and updated on what's going on. As attorneys, when we know we're working a sale with a realtor, we try to provide as up-to-date information as possible. We like to give the realtors real-time information as things happen. So as we move through a trial, we let them know. If we're going to a settlement conference, we let them know we want their input. And as professionals, you should feel free to reach out to the attorneys who are representing your clients and ask them, hey, what's going on with this case? How much longer is this going to take? Where are we at in the process? What can we expect? You knowing what's going on with the litigation is important to help you broker that transaction and finalize that for your clients. And then finally, just a little bit of defensive practice for you all as the professionals. We strongly recommend that you document your conversations with both parties. And if you're going to do that, we strongly recommend you do it by email, that you copy the attorneys who are involved, so there's no he said, she said later, that the attorneys aren't in court fighting and saying, oh, the agent told the husband one thing and told the wife something else, and now the whole deal's fallen apart. So keep your documentation, document often when you talk to your clients or potential buyers who are going through a divorce. And then on the other side of that, obviously, is try not to take sides. Anyone who's been through a divorce or going through a divorce, it's emotional. It's hard not to talk about it, and I have no doubt folks going through it want to talk about it with any professional they can get their hands on. They're going to bend your ear. They're going to want you to empathize with them. Do your best to remain impartial. Don't take sides. Again, quickest way to lose a sale or get kicked out of a sale is for an attorney to file a motion and say, hey, the agent is being unfair in this transaction and we want them removed and we want to start over. So if you just remain neutral, you shouldn't have that problem. The other thing is try not to provide your client's legal advice unless you also have a bar license. We recommend that you just defer to the attorneys if there's questions about the legal implications of what the sale means. And finally, it has been raised in a handful of cases I've done over the last 20 years that a real estate professional has overstepped their professional boundaries and developed a relationship with one of the litigants that's more personal in nature. And it's our recommendation that if you are the professional involved in the real estate transaction and the parties are going through a divorce, wait until the divorce is finalized, wait until the transaction is finalized before having that more personal relationship. Again, just don't want to lose a sale, don't want to lose the clients, don't want your ethics called into question. And if an attorney feels like a professional, a real estate professional is being unethical or overstepping, again, that's kind of the quickest way for us as attorneys to have you removed from a sale or a case. So just our quick little checklist on do's and don'ts. Again, working with divorcing clients. So here we want to give you some just tips and best practices in addition to our do's and don'ts. Primarily, again, first thing, it's important to be empathetic and understanding. These folks are going through a tough time. Their life is changing. The home that they lived in is being sold or refinanced, and one party is having to leave that home. They may have children involved. And so being empathetic to them and just kind of hearing them out, is super important. Again, try to maintain that consistent and clear communication. Don't mix your words. Don't make it vague. Be consistent. Be clear, and document your communication as much as you can. Next, establish boundaries and set your clients' expectations. So many times we hear in our divorce cases that somebody thinks their house is worth $5 million because a house around the corner from them sold for $5 million, and their house is unique and special and it's wonderful. And the reality is that the house can't even appraise for over $600,000. And so it's not just us as the attorneys that have to set those expectations and those boundaries. We really do rely on you all as the professionals to tell the clients, hey, look, yes, your house is great. We love it. You love it. But unfortunately, in this market, it's just not going to sell for the $5 million that you think it's worth. Again, that kind of just also goes back to the clear and consistent, but just set their expectations, make it reasonable for them, and keep your boundaries with them. Don't let them bully you or push you around or tell you, oh, well, I'm going to get my friend to do this listing and they'll list it for $5 million. I mean, just be clear and stand your ground. Try to avoid any kind of misunderstandings. Next, be patient. Again, emotions are high, things are changing, so try to be patient with folks going through this process. And this is, again, one where I would say, if you're not getting headway from the clients, feel free to reach out from the attorneys. If they're not signing that listing agreement, if they're not cooperating in selling the house, if they're, unwilling to make changes or repairs to the home, reach out to the attorneys and say, hey, we could really get top dollar for this house if you could just tell your client to make these repairs or to make sure the house is available on a Saturday. So don't be afraid to get the lawyers involved. And it's our job as the attorneys to make sure that our clients and your clients are doing what they need to do to get to the end of their case. And again, just stressing again, stay neutral, stay professional, and just do the best that you can. So a couple of communication strategies when you're dealing with folks who are in a real estate transaction and they're going through a divorce. Do your best to use those active listening skills. Listen to them, hear them out. Again, keep that clear and concise messaging and document. Again, use your regular updates. If something changes, if you get an offer, make sure that you're communicating that to them right away and to their attorneys. Um, if something happens and a transaction falls through, make sure you're communicating that as well. And then try to pick up on the nonverbal cues and be aware of what those look like and responsive to those during meetings and discussions. In the divorce world, we see a lot of power dynamics, a lot of power struggle, and you will likely see that too if you're dealing with divorcing clients. And so it's important, as you all talk about certain things that have to do with their real estate, that you're hearing from both sides and you're picking up on whether somebody's dominating the conversation or even intimidating the other side, which we see as well. So just some things to be mindful of, and some things to think about as you communicate with your clients. So some strategies and some approaches for handling jointly owned homes. So when we're talking about dividing a community home, one thing is to talk about, again, that fair market valuation and how we're going to get there. So as the realtor or as the professional involved, again, the attorneys are relying on you to tell us what is the fair market value of these people's property and where can we be realistic at a selling price or for buying out. How do we establish that, and what's a number that everybody can live with? And then next is to talk about buyout options. So is it realistic for these folks, for one party to buy the other party out? Can they get refinanced? Do they need an alimony award? Those are things that you need to think about and have those conversations with your clients about whether or not a buyout is reasonable. Once the home sells, we need to talk about how those proceeds are going to be divided and what the time frame looks like. And this is where, again, talking to the attorneys involved is super important. Attorneys may want money held in trust because even though the parties have sold their house, they still have to litigate other issues like alimony or child custody. And so it may be that the house is sold, but the parties aren't getting 100% of their sale proceeds. They may be getting 50% or 10%. And so it's important to have those conversations. Next, when you're negotiating the terms of a sale or a transfer of the home, you again want to make sure that it's clear, that you are remaining impartial, and that you are doing the best you can for your clients. So one of the other things that you need to talk about your clients with is their mortgages and their debts. So if you are selling a home and debts are going to be paid out of the sale proceeds, it's important to have an understanding of what that looks like. And then finally, you're going to want to talk to these folks again about just considering the tax implications of selling this house and whether they're going to buy something else or sit on the money and how that looks. So just going to go quickly over commercial property in divorce and some of the unique challenges that come up when we're dealing with commercial real estate and some special considerations. So when you're dealing with commercial real estate, getting a valuation can be very, very, very difficult. Commercial property, as I have learned over the years in handling divorce cases, is unlike really anything I've ever seen. One building can be located literally right next to another, and as an outsider, you can feel like, hey, this building is exactly the same, but from a commercial real estate standpoint, getting a value on the building can be very, very difficult. If you are a real estate professional and you're having a difficult time figuring out how to value this commercial building, it may be important to get in other professionals, appraisers, or even business valuators who have dealt with similar types of business to see if they can figure out how to come up with a value for the building. And then you need to think about how selling that building can impact these parties' business. So you may have a situation where parties are getting divorced and they own a building together. And maybe that building is occupied by a third party who's leasing it to do business. And will selling that business or selling that property impact that business? And do lease agreements, or um, other agreements with tenants who are occupying that building even allow for the landlord to sell the building and have somebody else operate it? And so those are things that you need to think about. Another issue that we are currently facing in a case in my firm is selling commercial property can take a really, really long time. I have an existing case where my client has been ordered to sell his commercial building, and I think it has been on the market for a little over a year, taking quite a while to get it sold. And that can cause a toll on your clients. And so it's important to explain to them that your divorce may be final, but you may not see proceeds from the sale of that commercial building for a really long time. And then again, just coming back to the legal and the tax implications of selling commercial property and what that looks like, and having those conversations with your clients, and making sure that they're referred to tax professionals to deal with that. So some other considerations that you're going to want to think about as you work with commercial real estate. Again, just figuring out what that business value is and how that commercial property plays in. You may have an owner-occupier of commercial property, and how we value the business may be affected by whether they own the commercial space that the business is in. And so your input and your take on that is going to be important. Again, going back to leasing agreements, and just making sure that if you're working with a divorcing party who's trying to sell some commercial property, that those lease agreements that they have allow for the sale or allow a new owner to continue to hold that tenant in that space, because that may be a consideration. Perhaps your divorcing owner may not want to sell if it means they're going to lose value on it, because the lease allows that tenant to vacate if somebody new buys the building. So those are things you need to think about. Other things, a little more, I guess, archaic, maybe the zoning and usage restrictions. Your owner may have a lease or a permit that allows them to do something that may not be transferable to somebody else. And so that can affect the value of the commercial property that's being sold. You're going to want to look at a market analysis and see, how does this commercial space stand up to other things? Is there a demand for this space? Would it be better for the owner to hang on to it for a little bit? Maybe you can't sell it right away. And so you may have to go back to your client and say, look, this is a space that's just not going to move in this market. You client need to talk to your attorney about trying to find another way to raise capital or to buy out your ex from that space. So another issue is, again, always the tax implications and what it looks like, including capital gains taxes if commercial property is sold. And then finally, one case that we've had recently where our client is getting divorced and he owns property in a business with other people, and he wants to buy out the spouse, and the folks that they own the commercial property with are not in agreement with that. They want to buy out both of their shares because the other partners don't want to deal with their divorce. And so that may be something to consider as well when you're dealing with clients who are looking at selling commercial property, and whether or not it makes sense for them to even go through that process, and then negotiating for them to sell to other folks in a business that they may own together. So those are some considerations that you need to keep in mind if you are dealing with divorcing spouses and looking at commercial real estate. So kind of one of the last things we want to touch on is the legal and financial considerations, liens, legal claims and compliance, and then financial management and escrow. So first, it's important to identify any existing liens. And if there are liens on property, again, as the legal professionals, we ask that you notify us because we may need to deal with those liens with court and how we're going to figure out who's responsible for those liens. Hopefully, the attorneys you're working with will have also looked at liens and can advise you as to any liens as well. You need to understand any legal claims that may go with that property, particularly in commercial property if somebody is being sued, if it's a premises case, if there's attachments on the property, or just any legal claims that may relate to the property. You need to be aware of those. Make sure that everything you're doing as far as sale and purchase is compliant with local and state laws. Again, address joint debts. Don't forget to talk to your clients about whether they're going to use their sale proceeds to pay the debts, or if there are, I've seen cases where Republic Services has put a lien on the property, and one spouse says, well, that's not my problem. It's not my responsibility to pay that lien. Well, if it's community property and both their names are on it and they're both getting sale proceeds, it would make sense that the payment of that lien would come out of both sides. So you just want to make sure that if there are any joint debts or any liens that exist on the property that's being established, make sure you're getting clear title, and understanding if there's any encumbrances or disputes, how that's going to work. One of the things as attorneys that we can do is place a lis pendens on real property if clients aren't paying our fees. And so that's going to be something that you'll want to address with the clients. You'll probably want to have that conversation with them and say, hey, look, you haven't paid your lawyers, and they've put a hold on your property, and you need to get them paid off before we can transfer title. And so again, that's where having that dialogue, communicating with the clients and the attorneys is really important. And then finally, again, like beating a dead horse, talking about tax considerations, and talk to your clients about what the tax considerations are for getting these properties sold. So just some ideas for some best practices if you are in the financial management and escrow part of this. First, you're going to want to make sure that those closing statements are absolutely completely clear about exactly what's being paid and exactly what the clients are getting when all is said and done. Make sure that escrow account is clear. Make sure that you are communicating clearly, unequivocally with the escrow agents, that there's no errors. Make sure that the clients understand their financial obligations, that they've got to make that last mortgage payment, they've got to pay the taxes, they've got to make sure all those liens are paid off, they got to make sure their lawyers are paid, and that all the financial obligations that are going to come out of their escrow account are taken care of. And then you as the real estate professional want to make sure that from beginning to end, it completely goes through and that there's no hiccups. If there are, again, reach out to counsel, talk to the attorneys, let them know that there's problems. As the practitioners in court, the last thing we want to hear about is they lost a sale or it didn't go through because there was an issue at escrow with something that we didn't know about and weren't told about. Usually we can deal with most of these issues in the divorce case and with a judge if needed, before we get to losing a sale or losing a transaction. And then finally, if money is going to be invested or going to some other asset besides the client or to a new purchase of real property, you're going to want to collaborate with their financial advisors and talk about how that money is going to be transferred. So we hope that this has been informative and helpful and has given you some strategies for understanding Nevada law, some of the key terms that we've talked about, understanding how people going through a divorce can be impacted by that and how that relates to their real property, their residential property and their commercial property. We've given you some considerations about how you as the real estate professional can help these folks, and some do's and don'ts for how to deal with them, and some strategies for handling the sale of their uh, personal real estate or commercial real estate. And finally, just want to leave you with the idea that communication is key. It's absolutely just the absolute necessity when you are dealing with folks that are going through a divorce. You want to make sure that you are clear, empathetic, and effectively communicating with everyone involved, not just buyers and sellers, but also with their attorneys and with the court as needed. And so that concludes our webinar. We hope you've enjoyed it. We hope that this has been helpful. If you need to get in touch with us, this is our contact information, and we sure would hope that you would provide us some feedback, which you can do by reaching out to us either by phone or at our email at staff@rosenblumlawlv.com. And we appreciate your time today. Thanks a lot.